Colin, what's on your radar?
This week we've discussed a long list of abusive practices and attacks on working people in this country. From companies that aren't fulfilling their agreements with mine workers in Alabama, to Amazon's long list of worker-based grievances and the Teamsters stepping in to help protect Amazon workers nationwide. And just when we think we might be done for the week, the Supreme Court deals yet another blow to working people, and in fact some of the hardest working, least protected people in this country, farm workers. The Supreme Court, breaking on partisan lines, ruled that the 1975 California statute that made it legal to organize, bargain collectively with their employers, and vote in secret elections was partly a violation of growers' private property rights. Specifically, it said, labor organizers can no longer visit the fields. This reversed a major victory won by Cesar Chavez's famous farm workers movement of the 1970s. The farm workers argued that because of both the seasonal and remote nature of farm work, access to workers on the farms was essential to ensure they were able to exercise their organizing rights. In 1975, California adopted this access regulation and granted collective bargaining rights to farm workers who were previously excluded from union organizing protections. Under that law, it allowed one labor organizer for every 15 workers to meet with workers for an hour before work, during lunch, and after work for up to 4 30-day periods per year. And they must formally notify the farm owners first. In short, it's hardly an invasion that would affect work compensation or productivity. First of all, most farm workers are paid by the piece, not by the hour. In short, you get paid for how many heads of lettuce you turn in, not how many hours it took you to pick them. These farm workers are paid by how many trays of strawberries they pick. Chief Justice Roberts wrote that allowing union organizing on the farmer's property amounted to taking of the property without just compensation. Dissenting judges disagree, saying that access legislation doesn't affect properties as nothing is either sold or transferred, essentially. In 1975, Cesar Chavez and the United Farm Workers Union viewed this access legislation as key to organizing and protecting workers. The farm owners immediately challenged this as an invasion of property rights. The California Supreme Court declined to hear the case in 1976. This could have a devastating effect on labor organizing, as it often occurs in workplaces. It changes the definition of per se takings, which normally involved extended physical occupation or deprived economically beneficial or physical use, to simple entry. We should all know that farm workers are some of the most essential jobs in our country. Despite the COVID shutdown, most of us all had continued access to the products grown, for instance, in California's green basket, things like fruits, vegetables, and almonds. Why? Because farm workers kept working. They toil in incredibly difficult conditions, in fact, some of the worst in the country, where they're subject to increased sickness and disease, and they regularly do this work in 100-degree heat and more. They deserve unfettered ability to fight for their rights and protections, and a ruling that says that in doing so, they're taking growers' land is absurd and sets a dangerous precedent for working people going forward. Robbie, what do you think? The Supreme Court now says that they cannot organize in workplaces. Well, if they're not going to organize in workplaces, where are they going to do it?
Yeah, I think this is, but the issue here is, right, the way things should be and the way things are. So the Supreme Court essentially just said, based on our reading of the Constitution, this violates it. You can't, without just compensation, use private land for some other purpose. I actually think the government has had too much license to take private land for public use. I'm very against eminent domain. I think it's the most abusive practice on earth. I don't think this is nearly as abusive as that, but I would still say, right, the Constitution prohibits the government from saying you have to let people onto your property, or that should be a stronger protection. And maybe we don't like it, maybe that's not good for the labor movement, but the Supreme Court, 6-3, said that's just what the Constitution says. Sorry. What can you do? Well, look,
I would say it isn't really about the labor movement itself. And it's not about, in my opinion, private property rights, because these things, while they're occurring on private property, are being done, before work, during lunch, and after work. Yes, they're utilizing the property, but they're not doing so.
If there was a law that said people could come into your house before in the morning and at lunch,
if I was employing people and my employment practices were potentially abusive, yeah, they should be able to do that. If I'm treating workers unfairly and they feel like they're being treated unfairly and they want to organize and say, hey, Colin, we want to fight for better working conditions, yeah, they should be allowed in. That's fine. That's fine. I don't actually have a problem with that. What I do have a problem with is treatment of workers in a, damaging way that's happening all across the country in multiple instances, and workers not having the ability in their workplaces to meet with labor organizers to say, what are we going to do about this? What are we going to do about the fact that, this piecework is underpaid? What are we going to do about the fact that we have no access to water right now? They can't do anything because they can't meet with a labor organizer who would teach them how they can talk to their employers about that. And I think that's just fundamentally abusive.
They just can't meet with them on the owner's property because the Constitution says you can't have a law that requires that.
So if you don't meet on the property in the place where the work is taking place, where are you going to meet?
Right.
I mean, this is the point. You can't meet, and the other point is a lot of these farm workers actually live in property that's on the same grower's land. So, they have small camps and places set up for them to live because they're migrants and they come here and they do the work and they stay in property that exists on the land. So there's fundamentally no place for them to actually have these conversations unless they're somehow able to organize people meeting off-site. Which, look, when it comes to farms and it comes to, the San Joaquin Valley in California where a lot of these protest movements occurred, you got to go a long way from these farms before you can get anywhere that you can actually meet, right? I mean, they are far out, they're sparse, and there's not a whole lot in between them. And so I just, I think when you start defining taking of the land, right, which is essentially what the Supreme Court is doing, as people having a meeting on the land, right, about labor practices that are occurring on that land, we're really taking away the rights of workers to be able to protect themselves from abusive practices. I just, and further, I think the idea that, in Amazon, they're not going to be able to have conversations about labor organizing with labor organizers anywhere near or on any part of the property that it's owned. It's just, how are workers actually going to protect themselves?
I understand the inconvenience. I understand it's a problem, but we have that provision of the Constitution exists because the framers were concerned about the government just confiscating people's property or using it for other having. I mean, this is an important provision for preventing the police from entering your property. There was a Supreme Court decision recently about that. Actually, about you need a warrant. Got to get a warrant to come in. I value as a libertarian, I really value that protection. I understand the issues you're raising, but sometimes the rights, civil liberties, and private property rights just are inconvenient.
They are inconvenient. I would argue that we should take a look at them, and when it comes to protecting people from abuses, there should be a better way to do it. And Team Rising joins us next.